By down the road, is it south or north or?
North, I would say, towards Hartford direction.
It states 123. I'm just going to open a map behind you, sir, if you could. Just is 376 Deer Cliff Road on that map?
Yes, it is.
If you could, wouldn't you mind please standing up and pointing to it? And Jefferson Crossing? Thank you. You can have a seat, sir. Here, and your seat's going to open, states 123, file marked 376 Deer Cliff, 1757 Fraught. Sir, if you could take a look at the screen behind you. What are we looking at?
That would be the soffit and camera on the front of the garage. And that would be Deer Cliff Road at the top of the screen.
So the white part on the right side of the screen is at the garage?
Yes, it is.
Okay. And Deer Cliff, you said it is at the road going from the upper left to the right of the screen?
Correct.
Jefferson Crossing, is that towards the left side of the screen or towards the right side of the screen if you were?
That would be to the left side.
Okay. The clip. And then you indicated, sir, you had one other camera?
Yes.
So it's going to play file mark 376 Deer Cliff, 1757 side. And again, sir, what are we looking at?
That would be the camera on the gable end of the garage facing Deer Cliff.
And that road going from the left to the bottom right at this point, is that Deer Cliff?
Yes, it is.
And Jefferson Crossing, where would that be, on the left or the right side of the screen?
Would be on the top left.
Now on the upper left, there's the date and time, 5/24/2019, and then 1757. Is that correct time, sir?
I believe so, yes.
Okay, I'm just gonna hit play.
I believe he said no.
And then, did you at some point enter the conversation as well?
Yes, I told him that I don't think those are cameras, but I told him, you know, if Jennifer wants to record you.
And was he concerned about picking up the children? Was that his concern, if you recall?
I don't recall it.
Okay. So that would pretty much be the offer, Judge. And if I may, you know, as I indicated, this is not being offered to prove the truth of any fact asserted. In fact, Mr. Doulos is asking questions. Mr. Zeisler saying it's not a camera. I'm not offering that for the truth of the matter asserted. And then that is being offered to prove a fact, except it's probative to the issue of, was Mr. Doulos concerned that there were cameras at 69 Wells Lane, which of course is extremely probative for the jury to understand whether or not he was planning this crime. Offered for its truth, and the court, of course, can give a limiting instruction on the appropriate purpose to the jury to minimize any potential prejudice to the defense. But it's not hearsay because I'm not offering it for its truth. So then it just becomes a question of relevance.
So the question the court has, Attorney McGinnis, is, would not the question, what was Fotis Doulos concerned about, avoid a hearsay objection?
So I actually think, and I mean this respectfully, Your Honor, I actually think that that would draw a hearsay objection, because then I apparently would be offering it to show what he was in fact concerned about. There could be a state of mind exception with respect to that. But I want to just ask him what Mr. Doulos was asking about. Certainly a question is not an assertion offered for the truth of the matter asserted. So our position is that this is a non-hearsay issue. It's just a question of basic relevance, and I think I've explained to the court why we believe that this is probative to the issue of whether or not Mr. Doulos was planning on committing this offense.
If I may respond briefly. Okay. First of all, this was the subject of a motion in limine on January 10th. This goes to the issue of hearsay. Now, I don't disagree with part of what Mr. McGinnis just said. It is true they have to prove that under the way they charge this, that Fotis Doulos committed an intentional murder. But this isn't Mr. Doulos's trial. It is Ms. Troconis' trial. Therefore, the rules of evidence don't go out the window just because Mr. Doulos is not on trial. If he
puts the burden on the court to determine what should be objected to. The court does not carry that role. If there are objections to be made, counsel is obligated to make them. The court is not going to carry that burden that counsel can ably carry. Do you wish to be heard, counsel?
No, Judge.
You can bring the jury in. Counsel stipulate, please.
Yes, Judge.
yes.
Mr. Committee, good morning again. Mr. Committee, I wanted to just go back to your 2001 Toyota Tacoma for a moment. In 2019, were the original Tacoma seats in the Tacoma?
No,
What types of seats were in the Tacoma in May of 2019?
I believe Ford Focus.
Were those Ford Focus seats in the vehicle when you purchased it?
No,
Who put the Ford Focus seats in the vehicle?
I did.
Why?
When I bought the car, I bought it from a mechanic, and they were just dirty red. And I decided to change them.
And do you recall where you purchased the seats?
It was mechanic in New Britain. I don't remember. I believe it was the same one I brought the Jennifer Range Rover to.
I believe where we left off prior to the break, you indicated that you had motorbiked or dirt biked with the defendant and Mr. Doulos. Is that correct?
Yes.
How many times did you do that?
Once just with Doulos and once with Doulos and Michelle.
And I believe you referred to an area as the power lines.
Yes.
Where is that area?
So, back left corner of Fort Jefferson, there was like a small trail that was connecting to it.
And how large was the trail?
Miles.
Can you describe the trail for the jury?
It's a white gravel road made for power line company, big trucks.
And approximately when did you dirt bike with the defendant and Mr. Doulos?
I can't remember. It had to be, I don't know, 2 weeks, few weeks before that, maybe month.
And I want to just be clear, when you say before that, what are you?
Before May 24 of 2019.
Incidentally, did you own a dirt bike when you came to America?
No.
When did you get a dirt bike?
I purchased that dirt bike from Michelle Troconis year or two prior to 2019.
What type of dirt bike was it?
It was Honda 250L, I believe.
How long did the three of you dirt bike for?
A few hours.
Was it fun?
Yeah.
And was this the only time that you had sort of seen Michelle Troconis outside of a formal work event?
I saw her at the Easter party. And like the hobby awards, but that, I guess that's considered work.
What are the hobby awards?
There was meetings with all the builders that would get awarded for best project, you know.
What year was this?
It was happening every year.
And was Four Group invited every year?
Yes,
And was there a year that Four Group actually got an award?
pretty much every time.
And would you attend?
Yes.
Who else would attend?
Whoever was managing
Your Honor, I would
them,
object to the vagueness. There's no time frame over the years.
Well, it would happen every year is the testimony. The witness said he worked for the Four Group for a certain number of years. And the question the court assumes is, did you go every year? That's what the court would assume. The logical question would be to respond to counsel's concern.
Well, why don't we talk about 2019? First of all, when were the hobby awards typically held?
when?
Yeah, what month?
I don't remember.
Do you recall whether or not there was a hobby awards in 2019?
I don't recall it, no.
Okay. How about 2018?
Yeah,
And who attended in 2018, if you recall?
it was me, Andy Loomis, Michelle Troconis, and Flores Dulos.
Now, Andy Loomis, would he have been, I guess, your counterpart on another project?
He was managing 80 Mountain Spring Road and 77 Mountain Spring Road. That was his project.
In May of 2019, what were the status of 80 Mountain Spring Road and 77 Mountain Spring Road?
They were finished.
And when a project is finished, what happens then?
It's on the market, waiting for potential buyer.
And were there any realtors that Four Group would work with usually?
Yes. One of them was Stefan Rach. And there was a few other ones. They came and go, but I don't remember their names.
Were there open houses at the projects?
Yes, every now and then.
And would you ever attend?
Yes.
You mentioned that you had purchased a dirt bike from the defendant. Where would you typically keep the dirt bike?
Typically would be
Any evidence. The court is reading that broadly. The court is not reading that as the first party to introduce this evidence is the party that is introducing this evidence. The court reads that as puts into evidence at any time, even through cross-examination. So, again, the fact that the stipulation reads introduce any evidence does not, in this court's view, indicate that the only way that evidence can be introduced is through other than cross-examination. The state does not intend to introduce evidence of the box. The state is introducing evidence of a bucket and a hoodie in the back of the Tacoma. How we get to the box at Attorney Knight's office is a mystery. In other words, the court is indicating that the fact that the state is introducing evidence of a bucket and a hoodie does not carry us to cross-examination concerning a box in the possession of Attorney Knight. So as the court did not read the second paragraph. In exchange for the defendant's agreement not to introduce said evidence and proceed as though the contents of the box do not exist, the state agrees that the first argument in its motion to disqualify filed on October 11, 2022 is now moot, to wit, that Schoenhorn is likely to be a necessary witness at trial, and thus there is a compelling need for his testimony. In order for us to even understand the stipulation, you have to understand the distinction between what's in the box and what's in the Tacoma. The state is representing that there's no evidence that what was in the Tacoma was in the box.
And I'm representing to the court that it very well may have, and therefore I'm a right to. He was questioned, forget about the box. He was questioned about a sweatshirt. Because when this sweatshirt was turned in, there was no DNA testing, et cetera, et cetera. He was shown a sweatshirt. He didn't recognize the initials on them that said CMR. I'm just looking at notes right now. Because this is a videotaped interview with this witness. I mean, technically, to the extent that it is relevant, I could cross-examine about the contents of the video. There's no mention of the box, if I recall, in that interview. He's shown a sweatshirt. He denies that it's his sweatshirt. He then says, well, this looks darker than the sweatshirt that I recall seeing. The problem is that these so-called blurry videos show a very dark, almost black hooded sweatshirt. So I'm saying this is a slippery slope because it's also putting, as I said, the cart before the horse. The court has to even entertain whether these clips, these fast clips of a blurry bicyclist have anything to do with this case. Anything. There's no one who's going to identify this other than the state claiming that they think it's Fotis Doulos riding on a bicycle. But the only sweatshirt that Mr. Gumieni is shown has his own DNA in it, and he doesn't understand why, and then later says, well, that could be mine.
Again, the court is reading the language shall not introduce broadly. And to put it in lay terms, no mention. That's how the court reads it. No mention at any time. So the court is going to allow the inquiry. Of course, these matters are preserved for appellate review. But again, the court is not going to choke the spirit of the stipulation by using, the court is going to use this term, a noose, for the term shall not introduce. We're not going to choke the stipulation for it simply to mean other than in cross-examination. We can bring the jury back in.
I'm not sure I understand. Does that mean the court is precluding me from cross-examining this witness about his interrogation by the police regarding them showing him a dark sweatshirt?
If that is contents of the box, yes.
Well, to be honest, I don't believe that the video indicates where it came from. I'm assuming that's what they showed him, but again, just based on the chronology. But I want to be clear that the court is precluding me from cross-examining the witness about being shown a sweatshirt that they told him had his DNA. He denied it was his, later said it might be his, but it was a different color. It was darker than the one he recalls seeing in a bucket.
McGinnis.
Judge, the defendant precluded herself when she entered into this agreement. Mr. Schoenhorn precluded himself when he entered into this agreement in exchange for the state withdrawing a very colorable motion to disqualify. And it is the height of disingenuousness to stand here and say, they showed him a sweatshirt from the contents of the box that I've agreed not under any circumstances to mention and proceed as though it doesn't exist, and then to cross-examine him about those very contents.
The court is in agreement with the characterization that it is the stipulation that precludes the cross-examination, not the court. We can bring the jury in.
We can discuss with Attorney Schoenhorn maybe tomorrow morning and see what we can give him a ballpark. But realistically, putting on the spot, I can't give you a day. Yeah, if we can, Your Honor.
Well, first, counsel indicated to the court indicated to the jury that March 1st was an overestimate. The court does not want to not keep the jury informed as to whether we're going to run up against that overestimate. That would not be fair. So if counsel would discuss the matter, the court can then determine how it will approach the jury if it looks like we're going to hit March 1st.
Yes, Judge, we'll discuss that. And actually, just while we're on this topic, I wasn't going to bring this up with the court now, but Attorney Schoenhorn raised the issue of witnesses coming from out of state. Can Mr. Gimini be excused for this?
Yes, you may be excused. Thank you.
I did just want to alert the court that Attorney Schoenhorn has given us 2 curriculum vitae for expert witnesses within the last week. I believe we got one on Friday, and we received another one today. We have no reports. We have no written explanation as to what they're going to testify to or what they relied on. We seem to be at a little bit of an impasse in terms of what is required in terms of reciprocal discovery. So I did just want to alert the court that we are going to be filing an appropriate motion because it seems that the defense just wants to give us the CVs and nothing else at this point, other than a brief oral summary of what the witnesses may say. And I don't think that that's sufficient under the practice book in our case law. So I did just want to alert the court that we're going to be filing an appropriate discovery motion, ask that that be heard sooner than later, because as we discuss scheduling, the state may very well move for quarter hearings on some of the proposed testimony, depending on what they indicate they're going to be introducing.
I want to be very clear. The practice book has been followed to the letter. There is nothing in the practice book that requires a person that we consult with to write a report. The CVs that we provide, in one case, it's like 50 pages long. So it's patently obvious what that individual is going to be testifying about. The other is also apparent from their field of expertise what they're going to testify about. Until there was certain testimony, I didn't even know that we would even need those witnesses. The fact that I had consulted with people over the years doesn't make them witnesses. So he can file whatever he wants. I have complied with what the practice book requires. The court cannot order an expert witness to prepare a report just because the state wants one.
Well, the court will take a look at the motion. What hasn't been done is to disclose, have those names been disclosed on that witness list to the jury?
Well, if Your Honor will recall, the list we provided was not a list of witnesses. So the fact that these two individuals were not on that, well, I don't even know if they were on the list. I can't recall. But assuming they were not on the list, these are people that until there was the state's, as soon as it became apparent that they may be called as witnesses, I provided the state with their extensive curriculum vitae. So other than and I gave them an oral discussion of what they're going to testify to. It's not scientific evidence, so there's no Porter hearing that is required. So that's just a red herring.
Yeah, that's not true, Judge, and I'll file the appropriate motion. I just, if the court wants to get a head start on the reading, I would direct the court to State versus Manusis. I don't have the exact site, but that'll point you in the right direction in terms of what the defense's obligations might be and what your discretion is in the interest of justice and fairness to the state, who is an interested party in this case.
Thank you. Well, tomorrow, Attorney McGinnis, how much more on direct do you think that you'll have?
Approximately an hour and 15 minutes.
Thank you. So the court would anticipate the whole day on cross tomorrow. That's what the court would anticipate.
Well, and since we don't even have an approximate date of the conclusion, I want the court to at least be aware now, I would probably have at least 4 days, full days of defense testimony. So if the court takes that into consideration in terms of where the state is going, the state has been putting everything that they have, relevant or not, in the record. So if there's any delay, it certainly isn't due to cross-examination. It was by the thorough, so I'm not suggesting it improper, but the thorough, perhaps over-thorough presentation by the state. But if there's any delay, it is not due to cross-examination. Most of my crosses have been relatively brief, considering the length of the direct.
Well, what the court recalls in discussions with both counsel is that the state was attempting to conclude by the 22nd. And so 4 court days, defense testimony would leave us the 23rd, the 26th, 27th, and the 28th. So if that is the schedule right now, of course we are running up against the overestimate, but the court has indicated to the jury that the amount of time you spend deliberating is up to you. We'll stand adjourned until tomorrow morning at 10 o'clock.
All rise. This honorable Superior Court